Welcome back to this second segment in contract law, acceptance, and at the break we were considering what happens in the context of silence when you're looking at acceptance. Well, in a case that we can use for some instruction, of course, is Housen Bindley in 1862. Now the facts of the case are these. The plaintiff entered into negotiations with his nephew, J, for the purpose of J's horse. He wrote to J shortly after, offering to buy the horse. And he famously said, "If I hear no more about it, I consider the horse is mine at £30, 15 shillings. Now, it was almost like buying a car in those days, of course. Now, J did not reply to his uncle's letter, but he did instruct the auctioneer, the defendant, not to sell the horse along with his J's farming stock. The defendant forgot this instruction, and 6 weeks after the plaintiff's letter, the horse was sold by the defendant to another person. Now, the plaintiff sued the defendant for conversion in tort, which is where you use somebody's goods as if it was your own, but outside the syllabus of contract law. So he sued the defendant for conversion, basing his action on the contention that there was a concluded contract between the plaintiff and J for the sale of the horse, and therefore the horse belonged to P at the time of the plaintiff at the time of the auction. But was there a binding agreement between the plaintiff and his nephew? Well, the court said that the action for conversion failed. Although the nephew may have decided to sell the horse to his uncle, there was no communication of this decision to the uncle. Accordingly, there was no binding agreement between the plaintiff and J, and the horse never became the uncle's property. Now then, let's consider the acceptance. It says, must be communicated by the offeree or someone authorized by the offeree. If you're looking at an acceptance, it cannot just be that I am thinking that I will accept. It must, of course, be told or communicated somehow. If someone accepts on behalf of the offeree without authorization, this will not be a valid acceptance. Case for that is Powell and Lee. And subject, of course, to certain exceptions, communication of acceptance requires that it is actually brought to the offerer's notice. So the general rule is that acceptance must be communicated to the offeror. Where the offeree notifies the offerer's agent of acceptance, this will be effective communication. So long as the agent has the authority to receive that acceptance, that will be acceptance. So again, looking at the general rule, acceptance must be communicated to the offeror. Until and unless the acceptance is so communicated, no contract comes into existence. Now, in situations which involve instant or instantaneous communication, such as face-to-face negotiations, telephone conversations, telex messages, and acceptance such as that, they must be actually received by the offeror. The cases that we tend to see showing this, of course, are in Torres and Miles for Eastern, which we'll consider shortly. Now, the contract is made, it said, at the place where the acceptance is received. Now, this rule has been applied also in the case of acceptance by fax machine. Now, a fax is a form of instantaneous communication for these purposes, and by analogy with telegrams and telex messages, an agreement is made on receipt of the message. Now, in the case of Torres, what happened there was that Torres was a London-based trading company that sent an offer for the purchase of copper, some type of copper product by telex from a company based in Amsterdam. The Dutch company sent an acceptance by telex. The contract was not fulfilled, and so Torres attempted to sue the owner of the Dutch company for damages. The controlling company, Miles Far East Corporation, was based in the US, and under English law, Torres could only bring the action in the US, serve notice of a writ outside the jurisdiction, etc., if it could be proved that the contract was formed within the jurisdiction, which is that in London rather than Amsterdam. Now, Lord Justice Denin, delivering the leading judgment, he said that the postal rule could not apply to instantaneous communications, such as telephone or telex. He said if a phone line went dead just before the offeree said yes, it would be absurd to assume that the contract was formed and that the parties would not have to call each other back. He said the same applied to telex. Since the contract was generally only formed when and where the telex was received, the place of formation was London. Subsequent cases, of course, like the Brinkmann case, we see that the defendants there hired a ship from the plaintiffs on the basis that the plaintiff could terminate the agreement if the defendants did not pay the regular hire charges. Now the defendants failed to pay, and the plaintiff sent them a telex to terminate the contract. It was sent during normal office hours, but the defendants did not see it until the next day. It was held that the withdrawal telex was effective from the time it arrived, not the time it was read. Now, it must be noted, of course, that this was a case relating to withdrawal of offers, not acceptance, but it is certainly a useful analogy. Now, I'm going to pause there and consider, how do you look at this situation in an exam question? Well, you will get exam questions which say, for example, that X and Y are dealing with particular communications. As I said, it's all about the communication when you look at this area. X sends some things to Y, Y sends something back to X, X sends something back to Y again. Is it an offer? Is it a counter offer? Is it acceptance? Is it invitation to treat? And all of this has to be considered. Well, in this context, the issue is whether or not, if persons are in negotiations and use, for example, a fax, and we see the examiner telling you something like it was sent outside of office hours. What does that mean? Well, we have the Brinkmann to back up what happens during office hours. So by analogy, you would have to respond to the question by saying, well, it was sent outside of office hours, and so it doesn't take effect until office hours. Equally, of course, if the examiner says to you that Y had told X that he was going on holiday from that evening, and so he left and there was no one to pick this up, then you would need to submit that arguably it may not amount to acceptance, but it is all dependent on the factual scenario that the examiner gives you. Another useful case in this area is the case of Brinkmann and Stagg-Stahl. It is the leading decision of the House of Lords on the formation of a contract using telecommunications. Now, the House of Lords largely accepted the earlier Torres decision in respect of acceptance via telex. Brinkmann was a London company that purchased steel from Stagg-Stahl, a seller based in Austria. Brinkmann sent their acceptance to Stagg, the offer by telex, to Vienna. Brinkmann later wanted to issue a writ against Stagg and applied to serve an out-of-jurisdiction writ on that party. They would only be able to do so if the contract had been formed in England. The question at issue was where the contract was formed. The Lords decided that the contract was formed in Vienna. They accepted the Torres principle, where in the case of instantaneous communication, which included telex, the formation occurs in the place where the acceptance is received. Again, it is important that when you look at the academic situation on an exam, for example, how this tends to manifest itself is the examiner may very well give you some sort of email situation. And the idea, of course, is that X sends the offer to Y, Y responds by email. The examiner then tells you that the email, there was network problems, and then he expects you to discuss it. Now, the point, of course, is that the academic commentary suggests that if you're using email, then along the lines of the Brinkmann and Torres and so on, The idea should be that once it hits, now with telex, it is when it hits that machine on the other side. Equally here, the academic commentary in respect of emails is that when it hits the server is when you're looking at the acceptance. So it is not about when it is read. So if the assumption is that it was sent during, say, office hours, then arguably there has been effective acceptance. The problem is if the examiner tells you there was network problems, they don't tell you if the network problems has occurred prior to it hitting the server or afterwards. Now, of course, if you're dealing with, for example, a UK law degree, then you will have to explain it along those lines. If you're doing some sort of international LLB like the University of London, for example, you should use what you know, what occurs in your jurisdiction. So, for example, in Jamaica, they have an actual statute dealing with offer and acceptance via electronic means, and it may very well be that you rely on that. But at common law, you would use the principles set out in NTORs, and you would certainly look to whether has it hit the server or not, and then you make submissions based on how you've taken the discussion. Now, there are of course exceptions to the need for communication. So where the offerer has waived the requirement for communication, and a discussion of that of course was set out in Feldhaus and Bindley, and certainly in the Carlyle and Carbolic smoke ball type cases, it's not required. But also consider if there is a prescribed method of acceptance or not. Because even if there's a prescribed method, there is an argument that you could use an equally effective method. So if it is that the offeror says that you should respond by post, if you were to hand deliver it, then it is equally effective, arguably. No case on the point, but certainly you would consider that. Now, as a general rule, an acceptance must be brought to the offerer's attention, as we've seen, for it to be effective. However, communication through the post provides the important exception to this general rule. What we will do after this short break that we're about to take is to continue looking at the exceptions and, of course, to consider the postal rule. We'll now take a short break.